there are two types of laws, a substantive law and a procedural law. Unless we understand this definition clearly, we may not be able to know what is the type of law that is Indian Penal Code Bhartiya Nyay Sanhita and what is the type of law that is Bhartiya Nagrik Suraksha Sanhita 2023. A substantive law is one where the rights, duties, and liabilities of the parties are defined. Take, for example, as Madam has said, Indian Penal Code, that is Bhartiya Nyay Sanhita. It is a substantive law. It is a substantive law because the law does not say you don't do that, you don't do this. It only says if you do this, you are punishable with this. If you commit a murder, sentence is death. They don't say don't commit murder. Take, for example, a civil case, a Transfer of Property Act. Transfer of Property Act is a civil law. It is a substantive law because it defines what do you mean by a property, what do you mean by sale, what do you mean by mortgage, what do you mean by gift, what do you mean by lease, license, etc. So that only tells you about the rights, duties, and liabilities of the parties involved in a transaction. But that itself is not enough. If a person has suffered on account of an act or omission which has been made punishable under any law for the time being in force, I am using these words consciously because we are talking about Bhartiya Nagrik Suraksha Sanhita and Bhartiya Sakshya Sanhita. Unless we know what do we mean by an offense, we will not be able to understand both the acts. The word offense has been defined in the Criminal Procedure Code and an equivalent provision in Nagarika Suraksha Sanhita also as under any act or omission which has been made punishable under any law for the time being in force is an offense. All acts and omissions are not punishable. At the most, the person who has suffered may claim damages from the court. That is a civil law. But if any act or omission has been made punishable under any penal law, either with an imprisonment or fine or both, that is called as an offense. So to constitute an offense, a person must have done something which ought not to have been done, or a person must have omitted to do something which he ought to have done. And such an act or omission must have been made punishable specifically under a particular provision of the penal law. That is called as an offense. Why I am telling about this? I am telling about this because the Indian Penal Code, that is Bhartiya Nyay Sanhita and Bhartiya Nagrik Suraksha Sanhita, are interconnected. Why? Because Bhartiya Nyay Sanhita speaks of the substantive law, as I told you already. But Bhartiya Suraksha Sanhita speaks of the procedure. What is that procedure about? Supposing I have been assaulted by somebody, or supposing my pocket has been stolen by somebody, I am the victim, as Madam has put it. So that will become an offense under old section 378 of the Indian Penal Code and the relevant section in the Bhartiya Nagarika Suraksha Sanhita. That is there. So Bhartiya Nyay Sanhita says it is a theft. Punishment is 3 years. Fine. But how to go about? Where to go for redressal? Which court I should approach? What is the manner in which I should approach? That is procedure. So that procedure is mentioned in Bhartiya Nagarika Suraksha Sanhita. Therefore, if you want to understand the criminal law properly, I don't say thorough understanding, because thorough understanding is for people who are actually involved in the judicial process, like judges, advocates, and all that. At least for you people, at least because you're all responsible persons from the media, you people should know how the system works, how the system works. So what is the relationship between the two? Why these two subjects are only amended now? Why not other laws? There are so many penal laws. Why not other laws have not been amended? The reason is Section 4 of Bhartiya Nagrik Suraksha Sanhita and the same Section 4 of Indian Penal Code, Criminal Procedure Code, has got two subsections. Subsection 1 says, all investigations, inquiry and trial in respect of the offences under Indian Penal Code, that is Bhartiya Nyay Sanhita, shall be conducted in accordance with the provisions of the Criminal Procedure Code only. To put it in a converted way, all investigations, inquiries and trial in respect of the offences under Bhartiya Nagrik Suraksha Sanhita 2023, Bhartiya Nyay Sanhita 2023 will have to be conducted in accordance with the provisions of Bhartiya Nagrik Suraksha Sanhita only. Then, okay sir, IPC is all right. There are other laws. So many other penal laws. Prevention of Corruption Act is there. Scheduled Caste and Scheduled Tribe, Prevention of Atrocities Act is there. NDPS Act is there. POCSO Act is there. There are a number of other penal laws. How to go about it? Is not CrPC applicable for that? A question may be put by wise people like you. The answer to that question is found in subsection 2 of the same section 4. In that subsection 2 says, if an offence is committed under any other law, that is other than Indian Penal Code, if the offence is committed under any other law, then all investigation, inquiry and trial shall be conducted accordance with the Code of Criminal Procedure only in Kerala. Code of Criminal Procedure, only word is not used. Code of Criminal Procedure or Bhartiya Nagrik Suraksha Sanhita. Now, from 1st of July onwards. But there is a rider. What is that rider? However, if there is any special provision in that special act, which is different from the provision mentioned in the Nagrik Suraksha Sanhita, then the provisions of the special law is applicable and not Bhartiya Nagrik Suraksha Sanhita. This fundamental aspect will have to be understood by us to know the interconnection or interplay between the Bhartiya Nagrik Suraksha Sanhita and Bhartiya Nyay Sanhita. So in that background, Madam has already addressed we all, about the Bhartiya Nagrik Suraksha Sanhita. And my job as interested by this esteemed institution is to discuss about the Bhartiya Nyay Sanhita. I will take 5 or 10 minutes before breaking for lunch. Why there was a need for substituting the old code with a new code? Bhartiya Nyay Sanhita is going to replace from 1st of July 2024 the Indian Penal Code of 1860, 1860, which was enacted by the British Parliament because India was the colony of the British Empire. So it was enacted by the British Parliament in the year 1860. So that code has been there even to this day for over a period of 164 years. Even after India became independent, we have been making use of the provisions under the code since last 75 years. But down the line, especially since last 20-30 years, if you see the way in which the country is developing, country is progressing in all fields, including in the field of science and technology, which has paved its way into every branch of human life. Every branch of human life. The lawmakers, the parliamentarians must have thought that this 1860 code may not be, all the provisions of 1864 may not be suitable or applicable for the contemporary situation. There is a need for bringing some more sections, some more provisions in the code in order to make it more vibrant and more accessible to a common man, and to make the ease of living of a common man comfortable. That is what the Honorable Home Minister has stated. I am just reading it. The object behind the introduction of new law is because the government considered it expedient and necessary to review the existing criminal law with an aim to strengthen law and order, and also focus on simplifying legal procedure so that ease of living is ensured to a common man. That is the main object. Ease of living is ensured to a common man. The government also considered to make existing law relevant to the contemporary situation and provide speedy justice to a common man. These are the twin objectives with which the Bhartiya Nyay Sanhita has been enacted, which would come into force from 1st of July. What is the overview of this? Overview of this new Sanhita. The Sanhita gives precedence to the offences against women and children, and also offences of murder and offences against the state. Some offences have been made gender neutral. Gender neutral. Of course, because I don't have much time to, otherwise, normally I take this subject for minimum 3 to 4 hours, either before the Academy for the Learned Judges or when I go to the Bar Association to address the advocates. But now there is a time constraint, therefore I want to complete it as brief as possible and as much qualitatively as possible. In order to deal effectively with the problem of organized crime, terrorist activities, new offences of terrorist acts and organized crimes have been included in the deterrent punishment, with deterrent punishment. This is one of the beautiful, because Section 111 of the Bhartiya Nyay Sanhita, Section 112 of the Bhartiya Nyay Sanhita, Section 113 of the Bhartiya Nyay Sanhita, Section 304 of the Bhartiya Nyay Sanhita, Section 152 and 103 subsection 2, 117 subsection 4 are all the new additions which were not there earlier. They deal with organized crime, petty organized crime, terrorist act, mob lynching, then doing an act against the sovereignty, integrity, and the unity of the country, affecting the sovereignty, unity, and integrity of the country, snatching, and community service. These are all the new introductions that have been introduced in the present Nyaya Sanhita, which was not there earlier. A new offense on acts of armed rebellion, subversive activities, separatist activities, or activities endangering the sovereignty or unity and integrity of India has also been added. The fines and punishments for various offences have also been suitably enhanced. And for the first time, community service has been introduced as a mode of punishment. These are some of the important takeaways from this newly introduced Bhartiya Nyay Sanhita. What is the structure of this? The structure of this Bhartiya Nyay Sanhita is like this. The Indian Penal Code of 1860 had 511 sections. Has. Still we are on 26th. Still 4 more days to go. Has 511 sections. Spread over 23 chapters. And Bhartiya Nyay Sanhita has got 358 sections. Spread over 20 chapters. Then you may ask a question. Sir, does it mean that 511 minus 358 has been taken away from the criminal law, penal law? My answer is no. It has not been taken away. It has been there, it is there in the new Sanhita also, but in a different form. So of course, some sections have been taken away. I don't say that. Some 11 to 12 sections have been taken away. But all the other important sections, whatever is there in the Indian Penal Code, is there in the Bhartiya Nyay Sanhita also, but in a different form. Now, then how is it that this Sanhita is more better than Indian Penal Code? I am talking from the point of convenience and quick reference. Convenience and quick reference. What do you mean by convenience and quick reference? If you go to Indian Penal Code, any law graduate is here? Any law graduate? Very good, sir. Thank you. If you have gone through the Indian Penal Code, you find in chapter 2, from section 6 to section 52A, it is captioned as general explanation. General explanation. Section 6 to section 52A. That is, 52 sections have been reserved in Indian Penal Code for general explanation only. But what the new Sanhita has done is, all these 52 minus 46 sections, 6 to 52A, 46 sections have been brought and grouped together under one section, that is section 2. And all other sections there have been made as subsections. So section 2 to section 2 subsection 1 to section 39 is section 7 to section 52A of Indian Penal. One thing. Section 6 of chapter 2, general explanation, I am telling, of Indian Penal Code, is the section 3 of the Bhartiya Nyay Sanhita. I am just telling you the structure. Then, that means it is very easy to make reference. Otherwise, for finding explanation for a particular word, for example, intention and knowledge, what do you mean by a voluntary act? What do you mean by a gender? When you want to search for a definition, you have to go through the entire section 7 to section 52A. But here it is not like that. All these have been grouped in a alphabetical order. So very easy to find out. So convenience, reference, and time saving. That is one thing. Of course, there are some improvements also here and there. I'll tell you about it. Very, very important improvements. Though the improvement appear to be very small, its magnitude is very great. Its magnitude is very great. Its dimension is very great. How I will explain to you. Then, there are offences of a particular category spread over in the Indian Penal Code under different chapters. For example, take offences against a woman and children. You find offences in not only in one chapter, in different chapters in the Indian Penal Code. And what the lawmakers have done here is, all those sections which deals with offences against women and children have been grouped under one chapter. It could be an offence of rape. It could be an offence of outraging the modesty of a woman. It could be an offence of a criminal force on a woman, an assault on a woman, kidnapping of a child, whatever it is. All offences, or intentionally insulting a woman, which are spread over in different chapters. For example, insulting a woman is 509 in IPC. Rape is 375. Outraging the modesty of a woman is 354. All those things have been brought and they have been grouped in one chapter. That means it helps advocates, judges, professors, academicians, and persons like you, everybody who is interested in knowing law, to make an easy and quick reference. This is another important change that has undergone in this Bhartiya Nyay Sanhita. I have only given one example of offences relating to women. All chapters have been arranged like that only, and I don't want to explain it because it takes unnecessary time. So this is the introduction which I would like to give before commencing the actual topic. If you want to break for lunch, I have no objection. And if you want me to continue, I will continue. I am prepared for both. It is for you to decide. It's for you to decide. In the definition clause, the new definition that has been added, which is not found in the Indian Penal Code, is the definition of the word child. they have said, it is said in the enactment, child means any person who has not attained the age of 18 years. That's all the amendment. But the significance of this amendment is very great. Why? Because if you go to the provisions of section 361, kidnapping a minor, kidnapping or abducting a minor, section 363 clause A, subsection 1, 2 and 3, the word used is minor. They have not used the word child. In the code I am telling. Whenever I say code, it is IPC, Indian Penal Code. Whenever I say Sanhita, it is Nyay Sanhita. So in the code, the word child is not used. The word minor is used. What if? What is that? What difference will it make? You may ask a question. Because the Indian Majority Act says, a person who has completed the age of 18 years is a major. So that means a person who has not completed 18 years is a minor. So what difference is there? There is a difference. What is the difference? Section 361 speaks of kidnapping a minor from a lawful custody or a lawful guardianship. The section 363 capital A subsection 1 of the Indian Penal Code, those sections are here also in Nyay Sanhita in the form of section 137 of Nyay Sanhita. Subsection 1 says, any person who kidnaps a child for the or any lawful guardian or a guardian who kidnaps a child for the purpose of employing that child for the purpose of begging. For the purpose of begging. Subsection 2 says, any person who maims the child, M-A-I-M-S, who maims the child for the purpose of begging. Subsection 3 says, any person who is not a lawful guardian, who has taken the child into his custody, and if the child remains in his custody, the law presumes that he has kidnapped the child. ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಆ ಮಗುವಿನ ಪೋಷಕನಾಗಿರಲಿ ಅಥವಾ ರಕ್ಷಕನಾಗಿರಲಿ ಇಲ್ಲದೆ ಇರತಕ್ಕಂತಹ ಪಕ್ಷದಲ್ಲಿ ಅವನೇನಾದರೂ ಆ ಮಗುನ ಅವನ ಹತ್ರ ಇಟ್ಕೊಂಡಿದ್ರೆ ಅವನಲ್ಲಿ ಲಾಫುಲ್ ಗಾರ್ಡಿಯನ್ನೂ ಅಲ್ಲ, ಪೋಷಕನೂ ಅಲ್ಲ, he has nothing to do with it, but he has a child with him. The presumption is, and his intention is to employ that child for the purpose of begging. Then the presumption is he has kidnapped the child. So wherever these three sections are there, the word used is a minor. The difficulty here is the minor is defined in subsection 4 in the same section 363A. There, according to this particular section, a minor is a person who has not attained 16 years of age in case of a male and 18 years of age in case of a female. So what is the consequence? The consequence is disastrous. How? If you go by that definition, old definition in 363A subsection 4, any person who is above 16 years and below 18 years is not covered under that particular type of offense. In case of male, I am telling, no female, no problem, 18 years. In case of a male child who has completed 16 years but not completed 18 years, he is not covered under this section 363, 361, 363A subsection 1, 2 and 3. So what should happen to such children who are minors for all purposes under the Majority Act? Indian Juvenile Justice Act says that any person who has not attained the age of 18 years is a juvenile. Prohibition of Child Marriage Act of 2006 says that any person who has not attained the age of 21 years in case of a male is a child. In case of a male. Prohibition of Child Marriage Act 2006. This anomaly is there. So in order to cure that anomaly, what the new law says is a child means a person who has not completed 18 years. So wherever the word minor is used in the old code, it is replaced with a child. Look at the beauty. One small definition, one small, addition of the word child has made such a magnificent changes in those penal provisions. That's what I told you. Though the amendment is very small, its impact is very huge. And in case of section 363, subsection 2 of the Indian Penal Code, it says that where a person maims the child, maims means making the child totally physically disabled. ಕೈ ಕತ್ತರಿಸೋದು, ಕಾಲು ಕತ್ತರಿಸೋದು, ಭಿಕ್ಷಾಟನೆ ಬಿಡೋದು. ದೇರ್ ವಾಸ್ ಒನ್ ಫಿಲಮ್, ನೋಡಿರ್ತಿರೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ವಯಸ್ಸು ನೋಡಿದ್ರೆ ನೋಡ್ದಂಗಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ ನನಗೆ. ವಿಷ್ಣುವರ್ಧನ್ ಅವ್ರದ್ದು ಬಹಳ ಬಹಳ ಹಳೆ ಫಿಲಮ್, ನಾವು ಕಾಲೇಜಲ್ಲಿ ಓದ್ತಿದ್ವೇನು. ಅದರಲ್ಲಿ ಇಬ್ಬರು ಮಕ್ಳು ಇರ್ತಾರೆ, ಅವಳಿ ಜವಳಿ. ಇವನ್ ಯಾವನೊಬ್ಬ ಆಂಟಿ ಸೋಷಿಯಲ್ ಎಲಿಮೆಂಟ್ ಕಿಡ್ನಾಪ್ ಮಾಡಿಬಿಡ್ತಾನೆ. ಕಿಡ್ನಾಪ್ ಮಾಡಿ ಅವನ ಮಕ್ಕಕ್ಕೆ ಆಸಿಡ್ ಹಾಕಿ ಬೆಗೆಂದು ಬಿಡ್ತಾನೆ. So that comes under section 363A subsection 2. A child is maimed for the purpose of employing it for begging, and from the arms that the child brings, he ekes out his livelihood. For that, under the old code, old ಅನ್ನೋ ಪದ ಉಪಯೋಗಿಸಬಾರ್ದು, ಇನ್ನೂ 5 ದಿವಸ ಇದೆ. Under the code, the punishment is may extend up to 10 years. Imprisonment, which may extend up to 10 years. But under the Nyay Sanhita, punishment shall not be less than 20 years. If a person maims the child, for the purpose of begging, the punishment shall not be less than 20 years. Under the code, it may extend to 10 years. So it could be 1 year also. It could be 6 months also. It could be 10 years also. But here, no discretion is given to the court. You must sentence him to minimum 20 years of imprisonment. That is a beautiful change that has taken place because of the addition of this particular definition. Adding of the word minor, so child, in place of a minor. Similarly, wherever the word minor is used in the code, it is replaced with the word child. So it will have its own impact or significance in the respective sections. That is one thing. Then, gender, Gender. In the code, gender is defined as he, he, and its derivatives includes she also. In the code, he includes she also. But in the new Sanhita, ಅದನ್ನು ಹಾಗೆ ಉಳಿಸ್ಕೊಂಡಿದ್ದಾರೆ, and includes transgender also. So the transgender also has been brought into the ambit of the definition of the word gender. Then the question is, who is a transgender? For that also explanation is given in the new Sanhita. Transgender means a person who has been defined as a transgender under section 19K of the under section 2K of the Transgender Protection of Rights Act of 2019. There is a separate act to protect the rights of a transgender called as Transgender Protection of Rights Act of 2019. So whatever the definition that is found to a word transgender in that particular act is imported here. That is another important significant change that has been made in the Nyay Sanhita. That's all. Only those two important definitions are there, but I'm bringing to your notice only the important definitions which are required for our to be cited within this limited time. Then I told you that the last section in the Indian Penal Code, 1860, is 511. 511 deals with attempt to commit an offense. He attempts to commit an offense, but it is spoiled by somebody. Attempt to commit an offense itself is an offense. Even if a person commits attempt to commit an offense, itself is an offense. For example, I have locked the door of my house and I have gone out. By the time I come, I find somebody trying to manipulate with the lock of my house and open it. His intention is to commit theft. I catch hold of him, subject him to the process of law. It is an attempt to commit theft. So when an attempt is made, he is punishable with an imprisonment which may extend to 1/2 of the maximum punishment provided for that particular offense. What do you mean by that? If a theft is committed under section 379 of the code, similar section is there in Sanhita also, the maximum punishment is it may extend up to 3 years or fine. So here it may extend up to 1.5 years or fine. That section 511 in IPC has been brought in the Nyay Sanhita at numerical 62. So section 62 is 511. Why I am telling this is, when we are reading the provision, so attempt to commit an offense is not an offense. You should not come to that conclusion. 511 has been brought under a separate category, that is abetment, criminal conspiracy or attempt. So it has been brought under a separate chapter, and 511 has been brought here as section 62. Then chapter 5. Chapter 5 deals with offences against women and child. This chapter has got 5 parts. The first part is sexual offences, section 63 to section 73. Code, section 375 and 376. Of criminal force and assault against a woman, section 74 to 77 of Sanhita is equal to section 354, 354A to D of Code. Of causing miscarriage, section 80, offences relating to marriage, section 80 to 87. Offences relating to causing miscarriage, 88 to 92. Offences against a child, section 93 to 99. All those offences which are in the Indian Penal Code have been brought here and categorized and grouped under one separate chapter of that particular category in 4 parts. Now, there is one beautiful change in this particular chapter dealing with of sexual offences. What is that? Section 63 defines rape. That is equal to section 375 of the Indian Penal Code. It defines what do we mean by rape, under what circumstances it could be considered as rape. 2 parts are there. In that context, 2 subsections are important. Number 1, a person committing a sexual act on a woman who is under the age of 18 years, age is very important, who is under the age of 18 years is rape whether she has consented or not consented. That is, consent is not material. If the woman is under the age of 18 years and if a man has committed such an act and he cannot plead, she has consented, therefore I did it, that consent is immaterial because it is a child. You can't take the consent of a child. A child's consent is no consent at all. Even Contract Act doesn't recognize any contract entered into a child. So what is the significance of this? When you come, there is one exception, exception 2, under the code. What is this exception? If a sexual act is committed by a husband on his own wife who is not under the age of 15 years, is not a rape. ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದು ಕಷ್ಟ ಇದು. is not a rape. That means they say if the wife is 15 years and above, and if an act is committed by the husband, it is not a rape. What is the anomaly here? Anomaly here is Human Rights Act of 1983 defines a child as a person who has not completed 18 years. A female. A general child. If you come to Prohibition of Child Marriage Act, a child is a person who has not completed 18 years in case of a female, and a male is 21 years in case of a male. If you come to Juvenile Justice Act, as I have already told you, any person who has not completed the age of 18 years is a juvenile. If you come to Domestic Violence Act, any child is a person who has not attained the age of 18 years. But here, if such an offense is committed by a husband on his own wife, don't mistake me for using the word own wife. Allirodu own wife ante nanu adike own wife ante ಹೇಳ್ತಾ. So, if such an act is committed on his own wife, and if that wife is 15 years more, 15 years and above, less than 18 years, it is not a rape. POCSO Act says that a child is a person who has not completed 18 years of age. Any person. It don't say, it does not include married woman. No, it don't say. So even if she is a married woman, for all purposes, if she is under the age of 18 years, she is a minor. She is a child. So POCSO Act says any such child is punishable for an aggravated sexual intercourse. Am I right, madam? Aggravated sexual intercourse, sexual harassment, for all that even a child is punishable if it is under the age of 18 years. But why this concession? Why this concession? If the wife is above the age of 15, above 15 years and under 18 years, it is not a rape. This is what, in one of the judgments of the Honorable Supreme Court, reported in 2017, Volume 10, Supreme Court Cases, page 800, in Independent Thought versus Union of India and another, the Supreme Court has pointed out this anomaly and directed they examined each and every option, whether this could be done, that could be done. They have examined each and every option. 4 options were there before the Supreme Court. All the 3 options were saying, no, it is not permissible. And last option 4, the Supreme Court said, therefore, there is absolutely no other option but to harmonize the system of law relating to children and require exception 2 to section 375 now to make it meaningful to read as sexual intercourse or sexual act by a man with his own wife, the wife not being under the age of 18 years. So now 15 has gone, 18 has come. When 15 has gone and 18 has come, it is harmonious construction with other sections, relevant similar sections found in other enactments which I have said. That is Human Rights Act, Domestic Violence Act, Prohibition of Domestic Violence Act, Prohibition of Child Marriage Act, and POCSO Act. In all these, Juvenile Justice Act, in all these acts, a child is defined as a person who is under the age of 18 years. So this is another important amendment that has been brought in the form of law, in exception 2 to subsection 2 of section 375 of the Code and section 63 of the Sanhita. And all other sections are, of course, remains the same. There is absolutely no change in that particular section 63 dealing with the rape. We saw with section 375. It remains, but one section has been added. What is that section? It is section 69.
Then in the
It's a good question. It's a good question. ಯಾವ ಲಾ ಪರ್ಮಿಟ್ ಮಾಡುತ್ತೆ ಅಲ್ಲ, ಯಾವ ಲಾನು ಪರ್ಮಿಟ್ ಮಾಡೋಲ್ಲ. ದಟ್ ಈಸ್ ವೈ ಚೈಲ್ಡ್ ಪ್ರಾಹಿಬಿಷನ್ ಆಕ್ಟ್ ಇಸ್ ದೇರ್. ನೀವು ಕೇಳಿದ್ದಕ್ಕೆ ಹೇಳಬೇಕು. ನಾನು ಯಾಕೆಂದ್ರೆ ಟೈಮ್ ಕನ್ಸ್ಟೆಂಟ್ ಇದೆ ಅಂತ ಜಾಸ್ತಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಕ್ಕೆ ಹೋಗಿಲ್ಲ. ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಅರ್ಧ ಗಂಟೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೋದು. ಚೈಲ್ಡ್ ಪ್ರಾಹಿಬಿಷನ್, ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಪ್ರಾಹಿಬಿಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ a child is a person who is under the age of 18 years in case of a female and under the age of 21 years in case of a male. ಇದು ಬಹಳ ಮುಖ್ಯ. ಯಾಕೆಂದ್ರೆ ಎಲಿಜಿಬಿಲಿಟಿ ಫಾರ್ ಗೆಟಿಂಗ್ ಮ್ಯಾರಿಡ್ ಈಸ್ child, a female should have completed 18 years and male should have completed 21 years. So if a male has not completed 21 years, under that act he is a child. You can't apply that definition here. ಅಲ್ಲಿ 21 ನಿಲ್ತರಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿ ಅದು ಆ ಆಕ್ಟ್ಗೆ ಮಾತ್ರ ಅವನ್ ಚೈಲ್ಡ್. ಅವ್ನಿಗೆ 21 ವರ್ಷ ಆಗಿದ್ರು ಸಹ ಅವನ್ ಚೈಲ್ಡ್. ಸೊ ಅವ್ರು 20 ವರ್ಷಕ್ಕೆ ಮದುವೆ ಆದರೆ he can be booked under the relevant provisions of the Child Prohibition Marriage Act. ನೀವು ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ, that act says that child marriage is voidable. ಇದು ಹೇಳ್ತಾ ಹೋದ್ರೆ ಬಹಳ ಮುಂದೆ ಕೊಟ್ಟು ಹೋಗುತ್ತೆ. ವಾಯ್ಡಬಲ್ ಅಂದ್ರೆ ಏನು? ವಾಯ್ಡಬಲ್ ಅಟ್ ದಿ ಬಿಹೆಸ್ಟ್ ಆಫ್ ದಿ ಬ್ರೈಡ್. ಏನ್ ಹಾಗಂದ್ರೆ, ಯಾವ ಹೆಣ್ಮಗಳು ಆ ಥರ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾಳೋ, ಯಾವ ಹೆಣ್ಮಗಳು ಆ ಥರ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾಳೋ, ಅವಳು ಬೇಕಾದ್ರೆ ಆ ಮ್ಯಾರೇಜ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಕೋಬಹುದು. ವಾಯ್ಡಬಲ್ ಅನ್ನೋ ಪದ ಸೆಂಟ್ರಲ್ ಆಕ್ಟಲ್ಲಿ ಉಪಯೋಗಿಸಿದೆ. ಆದರೆ ನಮ್ಮ ಸ್ಟೇಟ್ ಆಕ್ಟ್ ಅದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ತಂದಿದೆ. ಅದು ಐ ಥಿಂಕ್ ಮಾರ್ಚ್ 2003 ಏನೋ ಜಾರಿ ಬಂದಿದೆ. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಇಟ್ ಈಸ್ ನಾಟ್ ವಾಯ್ಡಬಲ್, ಇಟ್ ಈಸ್ ವಾಯ್ಡ್. ಇಟ್ ಈಸ್ ವಾಯ್ಡ್ ಅಂದ್ರೆ ಏನು? ಶೂನ್ಯ. That marriage is not at all deemed to be not in existence. They are not at all husband and wife. ಇದನ್ನ ಇದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಸ್ಟೇಟ್ ಮಾಡಿರೋ ಅಮೆಂಡ್ಮೆಂಟ್ನ ಅಪ್ರಿಷಿಯೇಟ್ ಕೇಳಿದ್ದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ದ ಮೋಸ್ಟ್ ಆಬ್ವಿಯಸ್ ಅಂಡ್ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ರೆಸಲ್ಯೂಷನ್ ಆಫ್ ದಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ರೊವೈಡೆಡ್ ಬೈ ದಿ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಓದ್ತಿರೋದು. ದ ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಚರ್ ಹ್ಯಾಸ್ ಇನ್ಸರ್ಟೆಡ್ ಸಬ್ಸೆಕ್ಷನ್ 1 capital A in section 3 of the prevention of prohibition of child marriage act, declaring that henceforth, that is from that day onwards, every child marriage that is solemnized is void ab initio. Ab initio means from the beginning. It is void from the beginning. So that has been appreciated. Adannu helbekalva, yakandre namge ade mukhya. Therefore the husband of a girl child would be liable for punishment for child marriage under the Prohibition of Child Marriage Act for penetrative sexual assault or aggravated penetrative sexual assault under the POCSO Act. And if the husband and the girl child are living together in the same or shared household for rape under IPC, our IPC too iವಾಗ change ಆಗ್ತಾ ಇದೆ. It would be wise for all the state legislatures to adopt the Karnataka formula. This is what the Supreme Court has said. So, this particular inclusion, or by substituting 18 years in place of 15 years, has got such a wide change in the field of, in protecting the rights of a female. Section 69, which has been amended, which has been inserted as a new section, reads like this. ಇಂಥ ಕೇಸುಗಳು ಇತ್ತೀಚೆಗೆ ಬಹಳ ಬರ್ತಾ ಇದೆ. ಮೊನ್ನೆನೋ ಪೇಪರ್ ಎಲ್ಲ ಅಪಿಯರ್ ಆಯಿತು. ಅದು ಯಾವುದೋ ಒಂದು, ಐ ಡೋಂಟ್ ರಿಮೆಂಬರ್, ಪೇಪರ್ ಕಟ್ಟಿಗೆ ನೋಡಿದ್ರೆ ಸಿಗಲಿಲ್ಲ ನನಗೆ. ಹೂ ಎವರ್ ಬೈ ಡಿಸೈಟ್ಫುಲ್ ಮೀನ್ಸ್ ಆರ್ ಬೈ ಮೇಕಿಂಗ್ ಎ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ಟು ಎ ವುಮನ್ ವಿತೌಟ್ ಎನಿ ಇಂಟೆನ್ಷನ್ ಆಫ್ ಫುಲ್ಫಿಲ್ಲಿಂಗ್ ದಿ ಸೇಮ್. ಎ ಮ್ಯಾನ್ ವುಡ್ ಪ್ರಾಮಿಸ್ ಎ ವುಮನ್, ನಾನು ನಿನ್ನ ಮದುವೆ ಮಾಡ್ಕೋತೀನಿ. ಪ್ರಾಮಿಸ್ ಮಾಡೋವಾಗ ಅವನು ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಇಂಟೆನ್ಷನ್ ಇರೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ಡಿಸಿಟ್. ವೆನ್ ಯು ಪ್ರಾಮಿಸ್ ಸಮಥಿಂಗ್ knowing within yourself that you cannot do it or you are not intending to perform it, that is called as a deceit. D-E-C-E-T. So, whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the promise has a sexual intercourse with her, such sexual intercourse not amounting to the offense of rape. ಅದು ರೇಪ್ ಅಲ್ಲ. ಅದು ಯಾಕೆ ಆಗೋದಿಲ್ಲ? ಬಿಕಾಸ್ ಅವ್ನು ಪ್ರಾಮಿಸ್ ಮಾಡಿರ್ತಾನೆ, ಅವಳು ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾನೆ. ಸೊ ಕನ್ಸೆಂಟ್ ಇಂದ ಆಕ್ಟ್ ಆಗಿರುತ್ತೆ. ದೇರ್ ಫೋರ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ರೇಪ್. ಆದರೆ ಮುಂದಕ್ಕೆ ನೋಡಿ, ಬಟ್ ದಟ್ ಪರ್ಸನ್ ಶಾಲ್ ಬಿ ಪನಿಷಬಲ್ with an imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Fine. Deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing the identity. That is also called as a deceitful means. So this is a new section which has been added into that particular chapter.
ಸರ್, ಈ ಲಿವಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲೆಲ್ಲ ಬಂದು ಈಗ ರೇಪ್ ಕೇಸ್ ಕೊಡ್ತಾ ಇದ್ದಾರಲ್ಲ ಲೇಟರ್ ಆನ್.
ಲಿವಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಮಾಡಿ ರೇಪ್ ಕೇಸ್ ಬಂದ್ರೆ ಬರೋದಿಲ್ಲ ಸರ್, ಬರೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಕನ್ಸೆಂಟ್ ಇರುತ್ತಲ್ಲ ಅಲ್ಲಿ. ವೆನ್ ಕನ್ಸೆಂಟ್ ಇಸ್ ದೇರ್, ಇಟ್ ಡಸಂಟ್ ಅಮೌಂಟ್ ಟು ಎ ರೇಪ್. Then one more change has been brought here. What is that one more change? There is one chapter in Indian Penal Code. In that chapter there is only one section, that is section 498A of cruelty to a woman. Yen helta section no, whoever being a husband, I am repeating the very section itself, whoever being a husband or his relative, subject a woman to cruelty. Al woman andre ಹೇಳ್ತೀನಿ, ಬೇರೆ ಏನು ಯಾರು ಅಲ್ಲ. ಯಾಕಂದ್ರೆ ಹಸ್ಬೆಂಡ್ ಅಂತ ಬಂದಿದೆ, ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ ಹಸ್ಬೆಂಡ್ ಅಂತ ಬಂದಿರೋದ್ರಿಂದ ಅಲ್ಲಿ ವುಮನ್ ಅಂದ್ರೆ ಇನ್ಯಾರು ಅನ್ಕೋಬೇಕಾಗಿಲ್ಲ. ಹಸ್ಬೆಂಡ್, ಆ ವುಮನ್ ಅಂದ್ರೆ ಹೇಳ್ತೀನಿ, ಹೂ ಎವರ್ ಬೀಯಿಂಗ್ ಎ ಹಸ್ಬೆಂಡ್ ಆರ್ ಇಸ್ ರಿಲೇಟಿವ್ subject a woman to cruelty, such person, that is such husband or his relative, shall be punished with an imprisonment which may extend to 3 years and fine. ಅದಕ್ಕೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ತಾರೆ ಎರಡು. IPC ನಾನು ಹೇಳ್ತಿರೋದು, ಅದಕ್ಕೆ ಎರಡು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ತಾರೆ. ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಎ, ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬಿ. ಕ್ರೂಯಲ್ಟಿ ಅಂದ್ರೆ ಏನು? ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಎ, ಫಿಸಿಕಲ್ ಕ್ರೂಯಲ್ಟಿ. ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬಿ, cruel treatment demanding dowry or some other material benefit from her in-laws, from his in-laws house. ಏನು ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ? ಹೊಸ ಕೋಡಲ್ಲಿ ಏನು ಚೇಂಜ್ ಆಗಿದೆ ಅಂದರೆ 498A ಸೆಕ್ಷನ್ನ ಸೆಕ್ಷನ್ 85 ಅಂತ ಇಟ್ಟಿದ್ದಾರೆ, ಎಕ್ಸ್ಪ್ಲನೇಷನ್ನ ಸೆಕ್ಷನ್ 86 ಅಂತ ಇಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಸೆಕ್ಷನ್ನು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ನು ಒಂದರಲ್ಲೇ ಇತ್ತು, ಇಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬೇರೆ ಸೆಕ್ಷನ್ ಬೇರೆ ಮಾಡಿ 85 ಮತ್ತು 86 ಮಾಡಿತ್ತು. Then there is one more addition in the form of section 95. Hiring, employing or engaging a child to commit an offense. Hiring, employing or engaging a child to commit an offense. Whoever hires, employs or engages any child to commit an offense shall be punished with an imprisonment of either description, which shall not be less than 3 years, but which may extend to 10 years. ಮುಂದಕ್ಕೆ ನೋಡಿ. And if the offense is committed, he shall be liable separately for that offense also. What do you mean by this? Supposing X hires a minor who has not completed 18 years for the purpose of committing an offense. ಆ ಮಗುನ ಸಹಾಯದಿಂದ ಏನೋ ಅಪರಾಧ ಮಾಡೋದಕ್ಕೆ ಆ ಮಗುನ ಹೈರ್ ಮಾಡ್ಕೋತಾರೆ ಅಥವಾ ಎಂಪ್ಲಾಯ್ ಮಾಡ್ಕೋತಾರೆ. ಆ ಥರ ಯಾವುದೋ ಒಂದು ಅಪರಾಧ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲರೂ ಕನ್ನಡ ಬರ್ತಲ್ಲ? ಓಕೆ. ಆ ರೀತಿ ಮಗುನ ಯಾವುದೋ ಒಂದು ಅಪರಾಧ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಎಂಪ್ಲಾಯ್ ಮಾಡ್ಕೊಳ್ಳೋದೇ ಅಫೆನ್ಸು. ಯಾಕೆ? ಇಂಟೆನ್ಷನ್ ಈಸ್ ಟು ಡೂ ಅನ್ ಇಲ್ಲೀಗಲ್ ಆಕ್ಟ್. ಕ್ರಿಮಿನಲ್ ಅಫೆನ್ಸ್ ಅಲ್ಲ, ಅಫೆನ್ಸ್ ಆಗಬೇಕಾದ್ರೆ ಇಂಟೆನ್ಷನ್ ಇರಬೇಕು, ಇಲ್ಲ ನಾಲೆಡ್ಜ್ ಇರಬೇಕು. ಎರಡೂ ಇರ್ಬೋದು ಬೇಕಾದ್ರೆ. ಸೊ ಎರಡೂ ಇಲ್ಲದೆ ಇದ್ರೆ ಅಫೆನ್ಸ್ ಆಗೋದೇ ಇಲ್ಲ. ದಟ್ ಈಸ್ ವಾಟ್ ವಿ ಕಾಲ್ ಇನ್ ಲೀಗಲ್ ಟರ್ಮ್ಸ್ ಆಸ್ ಮೆನ್ಸ್ ರಿಯಾ. ಸೊ ಇಂಟೆನ್ಷನ್ ಆ್ಯಂಡ್ ನಾಲೆಡ್ಜ್, ಇಂಟೆನ್ಷನ್ ಆರ್ ನಾಲೆಡ್ಜ್ ಮಸ್ಟ್ ಬಿ ಪ್ರೆಸೆಂಟ್. ಸೊ ಇಲ್ಲಿ ಒಂದು ಇಂಟೆನ್ಷನ್ ಏನು, ಆ ಮಗುನ ತಗೊಳ್ಳೋದು ಟು ಎಂಪ್ಲಾಯ್ ದಟ್ ಚೈಲ್ಡ್ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಕಮಿಟಿಂಗ್ ಅನ್ ಅಫೆನ್ಸ್. ಆ ಮಗು ಮೂಲಕ ಏನೋ ಒಂದು ಅಪರಾಧ ಮಾಡಿಸೋದು, ಅದೇ ಅಪರಾಧ. ಅದಕ್ಕೆ 3 ವರ್ಷ, ಕನಿಷ್ಠ 3 ವರ್ಷ ಶಿಕ್ಷೆ. ಆರ್ ಇಟ್ ಮೇ ಎಕ್ಸ್ಟೆಂಡ್ ಅಪ್ ಟು 10 years. ಒಂದು ನಿಮಿಷ, 10 years ಅಂಡ್ ಫೈನ್. ಆಯ್ತಾ? ಅವನು ಯಾವ ಅಪರಾಧ ಹುಡುಗನ ಕೈಯಲ್ಲಿ ಮಾಡಿಸ್ಬೇಕು ಅಥವಾ ಹುಡುಗಿ ಕೈಯಲ್ಲಿ ಮಾಡಿಸ್ಬೇಕು ಅಂತ ಇರ್ತಾನೆ, ಆ ಅಪರಾಧವನ್ನು ಮಾಡಿಸ್ಬಿಟ್ರೆ ಆ ಅಪರಾಧಕ್ಕೆ ಏನು ಶಿಕ್ಷೆ ಇರುತ್ತೋ ಆ ಶಿಕ್ಷೆನೂ ಉಂಟು. Supposing a person hires a female child for the purpose of using her for prostitution, and he uses her for prostitution, then he is punishable for 2 counts. One is for having employed that child or hired that child for using it for the purpose of committing an offense, which itself is an offense. For that he shall be punished with a minimum of 3 years. And secondly, if he employs that female girl for the purpose of prostitution, whatever the offense that is punishment that is provided for that offense, that also should be. That is another addition which has been done in this particular chapter. Then ಕೆಲವೊಂದು ಶೀಟ್ ಮಿಸ್ ಆಗಿದೆ, ಇರಲಿ ಪರವಾಗಿಲ್ಲ. ಇಲ್ಲ, ಸೆಕ್ಷನ್ ಇದೆ, ಇನ್ನೊಂದು ಶೀಟ್ ಎಲ್ಲ ಮಿಸ್ ಆಗಿದೆ, ನೋಡಿ. ನೆಕ್ಸ್ಟ್ ಚಾಪ್ಟರ್, ಆ ಚಾಪ್ಟರ್ ಮುಗೀತು ಅಷ್ಟೇ, ಅಮೆಂಡ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಚಾಪ್ಟರ್ ಆಫ್ ಅಫೆನ್ಸಸ್ ಎಗೇನೆಸ್ಟ್ ಹ್ಯೂಮನ್ ಬಾಡಿ. ಅಫೆನ್ಸಸ್ ಎಗೇನೆಸ್ಟ್ ಹ್ಯೂಮನ್ ಬಾಡಿ, ಮಾನವನ ಶರೀರದ ಮೇಲೆ, ಅಂದರೆ ಬದುಕಿರತಕ್ಕಂಥ ಮಾನವನ ಶರೀರದ ಮೇಲೆ ಯಾವುದಾದ್ರೂ ಅಪರಾಧ ಮಾಡಿದಾಗ ಅದಕ್ಕೆ ಏನೇನು ಶಿಕ್ಷೆಗಳಿದೆ. ಇಲ್ಲಿ there is one change that is in section 103. 103 BNS is equal to section 302 IPC. section 302 ಎಲ್ಲ ಗೊತ್ತಿದೆ ನಿಮಗೆ, ಟಿವಿ ನೋಡ್ತಾ ಇರ್ತೀವಿ. 302ನೇ ಸೆಕ್ಷನ್ ಪ್ರಕಾರ ನೀನು ಮರಣದಂಡನೆ ಕೊಟ್ಟಿದ್ದೀವಿ. So it is a punishment for murder. ಏನು ಹೇಳ್ತಾ ಸೆಕ್ಷನ್? ಎ ಪರ್ಸನ್ ಹೂ ಹ್ಯಾಸ್ ಕಮಿಟೆಡ್ ಮರ್ಡರ್ shall be punished with death or imprisonment for life and fine. ಅದು ಹಾಗೆ ಇದೆ, ಅದನ್ನ ಅದು ಹೇಗಿದೆಯೋ ಅದು ಭಾವತೆ ಇಲ್ಲಿ ತಂದ್ಬಿಟ್ಟಿದೆ. ಅದಕ್ಕೆ ಸಬ್ಸೆಕ್ಷನ್ 2 ಸೇರಿಸಿದ್ದಾರೆ, which is more dangerous, more heinous, which punishes more heinous offense. ಏನು? when 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or imprisonment for life. Sir? No comment. No comment. ನೀವೇನಾದ್ರೂ ಅನ್ಕೊಳ್ಳಿ, ನಿಮ್ಮ ಭಾವನೆಗೆ ಬಿಟ್ಟಿದ್ದು, ನನ್ನ ಕಡೆಯಿಂದ ಏನು ಕಾಮೆಂಟ್.
Simple thing is,
like, it's all right, sir. You can have your own feeling. Yes. You can't expect me to answer yes or no. Sir. When I say no comment, it is no comment.
One fundamental doubt.
One ನಿಮಿಷ ಸರ್.
ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮದ ಪ್ರಕಾರ ಅವ್ರು ವಿಚಾರಣೆ ನಡೆಯುತ್ತಾ ಕೇಸಲ್ಲಿ ಆಗಿರ್ಬೋದು ಅಥವಾ ಪ್ರಜ್ವಲ್ ಆಗಿರ್ಬೋದು, ಈ ಪ್ರಕರಣ
ಸರ್ ಯಾವುದೇ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಡೀಬೇಕಾದ್ರೆ ಸಾಕ್ಷಿಗಳ ಆಧಾರದ ಮೇಲೆ ನಡೀತದೆ.
ನ್ಯೂ ಲಾ ಪ್ರಕಾರ ಆಗುತ್ತಾ?
ಕಾನೂನು ಫಸ್ಟ್ ಜುಲೈಯಿಂದ
ಅದಕ್ಕೆ ಬರೋಣ, ಆಮೇಲೆ ಬರೋಣ.
ವಿಚಾರಣೆ
ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರೋಣ. ಅದಕ್ಕೆ ಆಮೇಲೆ
ಫಸ್ಟ್ ಕ್ಲಾಸ್ ಮುಗಿದ್ಬಿಡ್ಲಿ ಆಮೇಲೆ.
ಇಲ್ಲ ಕ್ಲಾಸ್ ಮುಗಿಯೋದು, ಕ್ಲಾಸಲ್ಲೇ ಹೇಳ್ತೀನಿ, ಏನ್ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಹೇಳ್ತೀನಿ, ಅವಾಗ ನೀವೇ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನು ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಆನ್ಸರ್ ಎನಿ ಕ್ವಶನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಕೇಸಸ್ ವಿಚ್ ಆರ್ ಬಿಂಗ್. Please don't ask me any question in respect of the cases which are pending, I will never answer. It is left to the due process of law. Law will take its own course. It is not proper for me to answer such questions.
One question.
Madam,
As you said, below the age of 18 years, when the marriage is void. So, what is the time frame after the marriage to be void?
Madam, your question is very perfect. But that question, if you want me to answer, I have to take you to the entire provisions of 2006 Act. Prohibition of Child Marriage Act ಅಂತ ಒಂದು ಆಕ್ಟ್ ಇದೆ, ಸೆಕ್ಷನ್ 2006 ಅಲ್ಲಿ ಬಂದಿದೆ. ಅದು ನಮ್ಮ ಸ್ಟೇಟ್ ಅಲ್ಲಿ 2018 ಅಲ್ಲಿ ಅಮೆಂಡ್ ಆಗಿದೆ. So I have to take you to the entire provision. There are about 22 sections in that act. I have to take. Therefore, kindly excuse me. Now, this time.
When that girl comes to know that.
Correct. ಅದೆಲ್ಲ ಇದೆ. That's what ಒಂದು ಸೆಕ್ಷನ್ ಇಲ್ಲಲ್ಲ, ಅದು 4 ಸೆಕ್ಷನ್ ಬರುತ್ತೆ. Therefore, I am telling positive of time ಇರೋದ್ರಿಂದ ಅದನ್ನ ಅದಕ್ಕೆ ತಿಳಿಸಿ. Your question is very pertinent. I don't say that your question is not pertinent. This is applicable. What I have read now, when 5 or more persons acting in concern commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, etc. ಇದಕ್ಕೆ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ನಾನು ಕೊಡೋಣ. ಏನು, ಯಾವುದೋ ಒಬ್ಬ ಧರ್ಮದ ಹುಡುಗ ಇನ್ಯಾವುದೋ ಧರ್ಮದ ಹುಡುಗಿ ಮದುವೆ ಆಗಿದ್ದಾನೆ ಇಟ್ಕೊಳ್ಳಿ ಎಕ್ಸಾಂಪಲ್. ಸೊ ಇನ್ಯಾವುದೋ ಧರ್ಮದ ಜನಕ್ಕೆ ಇವನ ಮೇಲೆ ಕೋಪ ಬರುತ್ತೆ. ಅವ್ರು ಗುಂಪು ಕಟ್ಕೊಂಡು ಬಂದು ಇವನಿಗೆ ಎದ್ವಾದದ್ದು ಹೊಡಿತಾರೆ, ಸಾಗಿಸ್ತಾರೆ. On the basis of race, caste, sex, religion. That is called as mob lynching. That is called lynching a person to death. Lynching a person to death without the intervention of the legal machinery. ನಾವೇನ್ ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ, ತಪ್ಪು ಮಾಡಿದ್ರೆ ತಗೊಂಡು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕೊಡ್ತೀವಿ, ಅಥವಾ ಒಂದು 4 ಜನ 4 ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ ತಗೊಂಡು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕೊಡ್ತೀವಿ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಪ್ರೋಸೆಸ್ ಆಫ್ ಲಾ. But instead of doing that, they take law into their hands and give a punishment either of death or of causing grievous. That is not right. In a civil society, that type of act is prohibited. Therefore, that has been made as an offence, and that is a new introduction in this Sanhita by way of section 103 subsection.
102 subsection 2 ಅಲ್ಲ
Sir, 103 subsection 2. Yes, this is a very important section. Accident cases. This has underwent a drastic change. ಇದುವರೆಗೂ ನಾವೇನ್ ಮಾಡ್ತಾ ಇದ್ವಿ, ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡ್ 4 ಸೆಕ್ಷನ್ ಇದೆ, 279, 337, 338, 304. 279, whoever does any act in a rash and negligent manner is punishable with an imprisonment so and so. 337 ಹೇಳುತ್ತೆ, whoever does any act on account of a rash and negligent act causes simple injury, he shall be punishable with so much of imprisonment. 338 ಹೇಳುತ್ತೆ, by the rash and negligent act, if grievous injury or grievous hurt is caused, punishment is dispensed. 304A ಹೇಳುತ್ತೆ, if death is caused, punishment is up to 2 years or fine. ಇತ್ತೀಚೆಗೆ ನಾವು ನೋಡ್ತಾ ಇದೀವಿ ಆಕ್ಸಿಡೆಂಟ್ಗಳಾಗ್ತಾ ಇರೋ ರೀತಿ ನಾವು ನೋಡ್ತಾ ಇದ್ದೀವಿ, ಹೇಗಾಗ್ತಾ ಇದೆ. ಅಂಡ್ ಆಕ್ಸಿಡೆಂಟ್ಸ್ ಆರ್ ಆನ್ ದಿ ರೈಸ್. ದಿನೇ ದಿನೇ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ, ಸಾವುಗಳು ಜಾಸ್ತಿ ಆಗ್ತದೆ. ಅಂಡ್ 2 ವರ್ಷ ಪನಿಷ್ಮೆಂಟ್ ಅಂದ್ರೆ ಕಾನೂನಲ್ಲಿ ಇಟ್ ಇಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಎ ಸಮನ್ಸ್ ಟ್ರಯಲ್ ಪ್ರೊಸೀಜರ್. ಪ್ರೊಸೀಜರ್ ಇಸ್ ವೆರಿ ಶಾರ್ಟ್. ಅಂಡ್ ಸೆಂಟೆನ್ಸು 2 ವರ್ಷ. ಅದಕ್ಕೆ ಕಾನೂನು ಮಾಡಿದವರು ಯೋಚನೆ ಮಾಡಿದ್ರು, ಓಹೋ ಈ ಕಾನೂನು ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ, ಇವರಿಗೆಲ್ಲ ಈ ತರ ಎಲ್ಲ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡೋರಿಗೆ ಇನ್ನು ಸ್ವಲ್ಪ ಸ್ಟ್ರಾಂಗ್ ಮಾಡಬೇಕು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಸೆಕ್ಷನ್ 106 ಆಫ್ ನ್ಯಾಯ ಸಂಹಿತ ಅದ್ರಲ್ಲಿ ಕಾನೂನು ತಗೊಂಡ್ರು, ನೀರು ತಗೊಂಡ್ರು. Whoever does any act in a rash and negligent manner, he shall be punished with an imprisonment which may extend up to 5 years. ಮುಂಚೆ 6 ತಿಂಗಳು 279 ಕರೆಕ್ಟ್ ಮೇಡಮ್, 6 ತಿಂಗಳಿತ್ತು, ಇವಾಗ 5 ವರ್ಷ ಮಾಡಿ. ಜಸ್ಟ್ ರ್ಯಾಶ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆಂಟ್ ಆಕ್ಟ್. ಸಾರಿ ವೆರಿ ಸಾರಿ. if any death is caused on account of a rash and negligent act, the punishment is enhanced from 2 years to 5 years. And fine, and they are fined to 11 fine. ಅದಕ್ಕೊಂದು ಆ್ಯಡ್ ಮಾಡಿ ಏನಂತ, and if that act is done by a registered medical practitioner while performing the medical procedure shall be punished with imprisonment which may extend to 2 years. ಡಾಕ್ಟರ್ಗೆ ಕನ್ಸೆಷನ್ 5 ವರ್ಷ ಅಲ್ಲ 2 ವರ್ಷ. ಅಂದ್ರೆ ಡಾಕ್ಟರ್ ಕನ್ಸೆಷನ್ ಕೊಟ್ಟರು ಅಂದ್ರೆ ಡಾಕ್ಟರ್ ಕಾರ್ ಡ್ರೈವ್ ಮಾಡ್ಕೊಂಡು ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲ, ಮೆಡಿಕಲ್ ಪ್ರೊಸೀಜರ್ ಮಾಡುವಾಗ ಏನಾದರೂ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿ ಅನಾಹುತ ಆಗಿ ಆ ಪೇಷಂಟ್ ಏನಾದರೂ ಸತ್ತೋದ್ರೆ ಆವಾಗ 5 ವರ್ಷದವರೆಗೂ ಶಿಕ್ಷೆ ಕೊಡಬೇಡಿ, ಅವ್ರಿಗೆ 2 ವರ್ಷ ಕೊಡಿ ಅಂತ ಮಾಡಿ. ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ ಮೆಡಿಕಲ್ ಪ್ರಾಕ್ಟೀಷನರ್ ಯಾರು ಅನ್ನೋದನ್ನು ಡಿಫೈನ್ ಮಾಡಿ. A registered medical practitioner is one who is a medical practitioner who possesses medical qualification registered under the National Medical Commission Act of 2019 and her name or his name is entered in the register maintained by the National Medical Commission or State Medical Commission. He is a registered medical practitioner. So this is so far as accident cases are concerned. ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಸ್ ಅಲ್ಲ, ಏನೇ ಆಕ್ಟ್ ಆಫ್ ರ್ಯಾಶ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆನ್ಸ್. ಪಾಪ ಡಾಕ್ಟರ್ ಆಪರೇಷನ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ಏನೋ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಗುತ್ತೆ. ಮೊನ್ನೆ ಒಂದು ಪೇಪರಲ್ಲಿ ಬಂತಲ್ಲ, ನೋಡಿರ್ಬೇಕು, ಒಬ್ಬ ಹೆಣ್ಮಗಳಿಗೆ ಲೇಬರ್ ಪೈನ್ಸ್ ಡೆವಲಪ್ ಆಗುತ್ತೆ. ಶಿ ಇಸ್ ಟೇಕನ್ ಟು ದಿ ಹಾಸ್ಪಿಟಲ್. ದ ಡಾಕ್ಟರ್ ಕಂಡಕ್ಟ್ಸ್ ಸಿಸೇರಿಯನ್ ಆಪರೇಷನ್, ಡೆಲಿವರಿ ಆಗುತ್ತೆ, ಸೇಫ್ ಡೆಲಿವರಿ. ಮನೆಗೆ ಬರ್ತಾರೆ ಮಗುನ್ ಕರ್ಕೊಂಡು. ಮನೆಗೆ ಬಂದು 15 ದಿವಸಕ್ಕೆ ಆ ಹೆಣ್ಮಗಳಿಗೆ ಪೇನ್ ಶುರುವಾಗುತ್ತೆ, ಅಬ್ಡಮಲ್ ಪೇನ್ ಶುರುವಾಗುತ್ತೆ. ಕೊನೆಗೆ ಅದು ಇಂಟಾಲರಬಲ್ ಪೇನ್ ಆಗ್ಬಿಡುತ್ತೆ. ಇದಕ್ಕೆ ಡಾಕ್ಟರ್ ಕ್ಯಾಶುಯಲ್ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡಿ, ಇಲ್ಲಮ್ಮ ಇಂಥವೆಲ್ಲ ಆಗುತ್ತೆ ಸಾಮಾನ್ಯವಾಗಿ, ಮಾತ್ರ ತಗೊಳ್ಳಿದ್ದೆ ಯಾವುದನ್ನ ಹಾಕ್ಬೇಕು. ಆಮೇಲೆ ಯಾರೋ ಬುದ್ಧಿವಂತ ಹತ್ರಕ್ಕೆ ಹೋಗ್ತಾರೆ, ಅಮ್ಮ ಸೆಕೆಂಡ್ ಒಪಿನಿಯನ್ ತಗೊಳ್ಳಿ, ಯಾವುದಕ್ಕೂ ನೀವು ನೆಗ್ಲೆಕ್ಟ್ ಮಾಡಬೇಡಿ. ಅವ್ರು ಇನ್ನೊಂದು ನರ್ಸಿಂಗ್ ಹೋಮ್ ಹೋಗ್ತಾರೆ. ಶಿ ವಾಸ್ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು ಅಲ್ಟ್ರಾಸೌಂಡ್. ದೇರ್ ಇಟ್ ವಾಸ್ ಫೌಂಡ್ ವೈಲ್ ಕಂಡಕ್ಟಿಂಗ್ ದಿ ಆಪರೇಷನ್ ಎ ಕಾಟನ್ ಸ್ವಾಬ್ ವಾಸ್ ಲೆಫ್ಟ್ ಇನ್ ದಿ ಅಬ್ಡಮನ್. ಅದು ಕೊಳತು ಅದೆಲ್ಲ ಹೊರಗಡೆ ಎಲ್ಲ. It is that which is possible. Then that lady filed a complaint before the consumer court. She got compensation of 20 lakhs. That's appeared in newspaper, maybe about 2 months back. So why I am telling is that negligence may cost so much. And if a death is caused, provisions of section 106 of the BNS and 304 of the